Good morning, everyone. I want to welcome you out to our seminar this morning. We're really privileged to have Mr. Perry to come and present this for us and his staff. And looks like a hardy bunch here this morning facing this weather, so that's good. Glad y'all could come out. I know it's pretty cold out. Of course, they say in Washington, D.C. this morning I heard it was so cold that the politicians had their hands in their own pockets, so we could have it worse. We could have it worse than we do. So right now, I'd like to present Mr. Audie Perry.
All right. Good morning. Good morning. We do appreciate everyone coming out this morning. I'm a mover, so I'm just going to walk with this. I can't stand still. I do want to briefly introduce your other speakers later on today, which will be Miss Anna Price and Catherine Davis, also from the Legacy Planning Group at Huddleston Bowling. Is that too loud? Is that good? How far? About right there? Yeah. All right, good. So I'll have one thing. All right, so man always wanted to buy a talking bird, okay? He had saved up his money for his entire life for his dream of owning a talking bird. So he finally makes enough money. He goes to the pet store. He tells the owner, I would love to own a talking bird. And the pet store owner goes, oh, I've got the perfect one for you. It speaks 7 languages and has deep philosophical conversations. Man says, I'd love it. So he buys it, takes it home, doesn't talk. He goes back to the pet store the next day and said, the bird, the philosophical conversation bird that I bought, it hadn't said a word. And the pet store owner said, well, I don't understand. It didn't climb up that little ladder and just start talking? And the man goes, well, I don't have a ladder. Oh, well, you got to have a ladder. Well, how much is a ladder? $15.95. Okay, so he buys the ladder, he takes it home, puts it in, comes back the next day. The bird still doesn't talk. Well, the pet store owner said, I don't understand. So he climbs that little ladder, he gets in his little hoop swing, and he starts talking. Hoop swing, $12.95. All right, go home. You see the point. He goes back, it still doesn't talk. Another day goes by. Pet store owner says, I'm so sorry, sir. Let me make sure I understand. He climbs his little ladder. He swings in his hoop swing. He rings that little bell and starts talking. Bell, $10.95. He's getting really perturbed at this point. He has more patience than most of us. He goes back again, and this time he's very irate. And the pet store says, sir, I promise. He climbs that little ladder, he swings in that little hoop swing, he rings that bell, and then you whistle, shh, and he will talk. Man storms out of the pet store. Sure enough, the bird did talk. It climbed that little ladder, it swung in its little hoop swing, it rang its little bell, and when the man whistled, shh, it said, food, stupid, and died. All right, so what's the point of that? The point is, so often with estate planning, we get so caught up in jumping through hoops and the bells and whistles that we forget the basics, all right? And so today we're going to talk about those basics to make sure we have a good foundation and we don't end up like that bird without any help. Anna and Catherine are going to pass out a little outline. Each one of us will have a little something to hand you so we can pass it all out. Great. Yeah, you'll have 3 handouts. What we're going to do today, I'm going to spend some time with you talking about the foundational documents that are available to you for your estate planning and should be included in everyone's estate planning, regardless of your level of assets. And then Miss Catherine is going to be speaking to you about a estate planning questionnaire. Questions that you should know or at least have thought about before you go visit with a lawyer to talk about your estate planning. It will help you get ready for that meeting and hopefully save you money so they don't charge you while you're sitting there trying to spell all your children's names. You already have all that taken care of. Then Miss Anna will be handing you'll also have what we call a questionnaire after you've executed your estate planning documents. And that one is to tell your loved ones who you leave behind someday. Now, I'm going to go ahead and say one thing right now. I had a law school professor. He taught me well. He never said anyone died. He said your will matured. All right. So someday your will mature. All right. Anyway, and this questionnaire is for loved ones to tell them where things are and what your wishes were. So we're going to talk about the foundational documents. We're going to talk about pre-planning and then post-questionnaire. All right? At any time, feel free to raise your hand and ask a question. If we can get to it right then, I will answer it right then. If we need to come back to it, I will write it down, and then we will save times for questions at the end, okay? But feel free to ask a question during so, because your question may help steer the conversation in a way that is helpful for everyone. One thing I want to get out of the way right in the beginning is the thing that steers much of the conversation that you will see in the newspapers in the next couple of months. And that is the concept of the unified credit. All right? The unified credit is the amount which the government allows U.S. citizens to pass either during life or at death without paying the estate tax or gift tax or the death tax, whichever you want to call it, okay? Conceptually, right now in 2012, each of you have $5,120,000 to give away during your life. Woo! Aren't we all doing great? The bad news is that goes away on December 31st of this year and drops all the way down to $1 million if Congress does nothing. Now, I know that's a little bit of an oxymoron, but that is the law. So $1 million still sounds like a lot, and it is. But let me just show you real quick. High-tech devices here. You ready? This sheet says Exhibit A. I want you to think of Exhibit A as everything in your life that you possibly have an interest in. It's the face value of life insurance. It's the full value of your retirement plan. It's your home, even though it's owned jointly with someone else. It's your checking account, even though it's jointly owned with someone else. It's the life estate that you have in your grandmother's farm. Everything you can possibly have an interest in. Okay, that's Exhibit A. Exhibit B is that which the government taxes upon your death. Can you read that? It says see Exhibit A for those who can. All right. So everything that you can possibly have an interest in is included in that $1 million that's coming. And, the trap for the unwary there is face value of life insurance. A lot of people don't, they have that term policy for $1 million that came through or whatever. Well, just became taxable. Now, we hope that Congress will agree to some other number, a higher number, and most of us believe that to be true, but we have to plan with the facts as we know that, okay? We will now move away from taxes. If later on you'd like to talk about that more, we certainly can, but there's three primary ways to avoid that estate tax. One is with a unified credit trust. So upon your death, you capture your unified credit, so you get to use yours and your spouse's if you're married. That way, together, you could shield $2 million under the law or $10,240,000 under this year. The other way is if you leave anything to your spouse, that's not taxed at that time, but that's another trap for the unwary. You're like, yay, we own everything joint. We're going to be fine. Well, let's walk through that. Let's go back to the $1 million example. You have $1 million. You die. You leave everything to your spouse. Your spouse now has $2 million. And what's their unified credit? 1. So your kids lose $400,000 to the tax man. So you need to plan to avoid that. And then the last, obviously, is charitable. Anything you leave to a 501c3 charity will not be counted against you for estate tax purposes. All right. So we're going to move off of taxes and talk about those basic tools. First one, tell me what you think of when you hear estate planning. What document? The will, that's right. And that is the primary estate planning vehicle. The number one reason you have for a will is, and there are many, but the primary one is to set forth where you want your assets to go. All right? Now, very important concept here. There are two types of assets, probate and non-probate. Okay, has anybody heard those terms before? Okay, probate are things controlled by your will, things held in your name alone that don't have an outside contract. Example, a checking account in your name, a piece of real estate in your name alone. Non-probate are all other assets that are controlled by an outside contract. Examples, life insurance. What's the outside contract? What controls where that money's going to go? It's a beneficiary designation, right? How about your retirement plan, your IRA or your 401k? How's it going to be controlled? Beneficiary designation. How about your home, joint tenants with right of survivorship on the deed? How about your savings account over at the bank where you have it jointly with someone else? The back of that card says it goes to that person upon your death. So here's another trap for the unwary. I leave a will that leaves everything to Anna, okay? So Anna's very excited. However, everything I own is joint with Miss McLeod. Hey, see? So upon my death, Anna's going to, and I appoint Anna my executor, so she's very excited. She goes over, she probates my will, and she shows everybody that everything I had goes to her. And how much is Anna going to end up with? Zero. Even though my will, she gets all my debts, basically. You're welcome, Anna. So you got to be careful. Just because you signed a will, you also have to understand how your assets are owned. And those beneficiary designations become important. What? Yes, sir.
You can, on savings accounts and so on, you can designate a person that says payable on death.
Correct.
Which to me means that I think they get this as a gift and it's not taxed. Am I right?
Correct. And that's another example of a non-probate asset. Did everybody hear that? He said, what about a savings account that's POD, payable on death? To somebody else. That's example. My will, again, could leave everything to Anna, but my payable on death savings account goes to Miss McLeod. So who gets it? Miss McLeod, right. Because it's controlled by an outside contract. So my main point there is please understand how your assets are owned, because it makes the difference on where, if your estate plan is really going to happen. It's okay to have non-probate assets. Just make sure you know the difference between that and your will. Okay? Because your will's only going to control the things with your name alone, or that you've designated one of those non-probate assets in a beneficiary designation to come to your estate. Not always the best thing to do, but we can talk about that. While we're talking about jointly held accounts, and I see a number of bankers in here, and they probably could speak the pain and heartache of this as much as I. Many people have children, one who lives here and one who lives in California or Florida, somewhere else, right? How many people have children that live both here and away? Yeah. Okay. So as we get older, we say, gosh, it would be nice if Susie, my daughter here, could sign my checks. So I'm going to put Susie on my checking account. And